33.
33.
Lordship, here we have to file our affidavit, Lordship. I am appearing for respondent number 4, 5, and 6. I've taken the consent, Lordship.
Okay. No, 33. Mr. S.S. Roy.
Our affidavit.
Learned Counsel for the respondent number
4, 5,
4,
and
5, and
6.
submitted that he has entered appearance. Learned Counsel has submitted that he has entered appearance for the respondent number 4, 5, and 6. So he has further submitted that 3 weeks time be granted.
Lordship.
2. File counter affidavit on behalf of the said respondents. It is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. The prayer is allowed till the case after 3 weeks. Interim order passed.
Millard, I have prayer in item number 9, Millard. Today, Millard, I have a medical emergency, Millard. My son is not well, Millard. I'm praying before your lordship just to list the case.
9 item.
Item 9, Millard. Lordship will kindly post this case on any other day, Millard, in the next week, Millard.
9. Okay, we'll ask the council, state council, whether they have obtained instruction or not. Then it will be
In fact, Millard,
adjourned.
Millard, till Monday, Millard.
It will be adjourned for a week. Let them say whether they have obtained or not.
17.
Hmm?
The instruction is still available.
Wait. Mr. Jade Hamad, learned counsel for the petitioners, has submitted that he has some personal difficulty to attend the court today and has prayed for an adjournment. Post of MS M. Borman, Junior Government Advocate Assam, is paying for the respondent number 2, 3, and 4. Has submitted that instructions in deference to the order dated 29/1/2024 are awaited. Post of having regard to the above submissions, the case is adjourned till 21.
Millard, till then, Millard, the interim may kindly be extended, Millard.
This is the case accordingly 21. The interim order passed earlier shall continue till the next.
Highly obliged, Millard.
May it please, your lord. My lord, I beg to mention item number 15, my lord.
15.
My lord, we have filed our affidavit on 7th, my lord. But that has not been tagged, my lord.
Oh.
I may be allowed to give the request. In that matter, we file and reply.
Okay. Heard Mr. B.P. Bora, learned counsel for the petitioner, and Mr. Z. Busho, learned standing counsel ZHC. Post of Mr. Busho has submitted that counter affidavit on behalf of the respondent ZHC has been filed recently, but the said counter affidavit is not tagged with the record. Post of on the other hand, Mr. Bora, who has received a copy of the said counter affidavit, has paid for 2 weeks time, 2 weeks to file affidavit in reply to the said affidavit. Counter affidavit. Release the case. After prayer made by Mr. Bora is allowed. Release the case after. What date did you? 6/3.
Obliged, Your
May I please, Lordship, with respect to item number 12, Lordship.
12.
That relating to payment of gratuity act. Lordship, I require to file one additional affidavit because they approach tribunal with prayer for seeking permanent status, Lordship.
Permanent?
Status. Because they were appointed as a casual. So this is bearing on this case also. I'll file an.
Permanent status.
Yes, Lord.
Okay. Mr. S.C. Cal, and counsel, standing counsel.
GST, CGST.
CBIC.
CGST.
CBIC.
Lordship,
Central Board of Indirect
Yes,
Taxation,
that's-
CBIC,
CBS,
CBIC. Appearing for the appellant, oh, sorry, petitioner, has paid for listing of the petition after
10 days.
10 days. Full stop. In order to file an additional affidavit,
Lordship,
full stop, the query is allowed, list the case.
much of.
When?
Let's say after 10 days, Lordship.
Today is
Today is
Nine.
9.
19?
Yes, Lordship.
There is the case on 19.
Maybe, I wish to mention item number 5 and 7, my lord. Mr. P.K.
5 and
P.K.
7.
Roy Choudhury, my lord, he is not able to report today, my lord.
5 and 7.
Seven. My lord, next week, my lord, any date, my lord.
Okay, Mr.
A.K.
A.K. Azad,
My lord,
on the prayer of Mr. A.K. Azad, 5 of it. Appearing for Mr. P.K. Roy Choudhury,
my lord.
learned counsel for the petitioner. Case stands adjourned for you. Similarly, 7.
My lord. Obliged.
May I please, your lordship? My lord, I beg to mention for listing of a motion item, my lord, next week, my lord, any date. My lord, another old pending matter, my lord. It's a matter,
Whole pending matter of which year?
my lord, of 2022, my lord.
That is not categorized in the old category.
My lord, no. Any date, my lord. Please take on, my lord.
But what? Subject matter?
Subject matter is that my lordship is well aware that Panbari Rangamati Mosque, my lord. It is a privately managed mosque, and in that mosque, my lord, government has issued an order for constitution of the managing committee, my lord. That order is under challenge, my lord.
Okay, next week.
My lord. Obliged.
May I please, your lordship? Lord, I beg to mention item number 14, my lord. In this case,
15,
14, my lord, 1/4. My
14.
lord, for no
Yes.
order, for
Yes,
no steps, my lord. So I may be allowed some time.
wait for your turn.
I'll-
Order, wait for your turn.
My lord, no step, my lord. Highly avoided.
Yes,
May I please, lordship? Lordship, I beg to mention for admission, my lord.
subject,
Railway tender, railway tender,
huh?
railway tender.
Make the mention before transport.
Please, ma'am. Hey, please, your lordship, I beg to mention one IA for listing. The IA is filed under Rule 5 Order 20 CPC for alternative mode of service to the upon the respondents.
Substituted. Then it will be listed. I will be listed. Yeah. In due course. You have filed.
Yes, madam.
Okay. ठीक है, I will take that.
May I please, your lordship? Lordship, I beg to mention for listing of a matter for admission, lordship. The matter pertains to eviction, lordship. Eviction,
Eviction,
lordship.
no stay.
Lordship, status quo was granted by this honorable court, lordship.
So?
I'm appealing for respondent number 9. The
You are respondent number 9. Who is respondent number 9? Private party.
lordship, he's the president of the Bathau Community Ashram, lordship. President of the Bathau Community Ashram.
Okay. Side you.
19, lord, or 19, lordship.
Court master will
Obliged,
find
lordship.
it.
May I plead your lordship? Lordship, in item number 28, we filed an affidavit in reply today, lordship.
Affidavit in reply
Lordship,
today.
lordship. So that may be called. Much obliged.
Please, your lordship, with the consent from the other side, I beg to mention item number 11.
11.
Yes, your lordship. Matter may be taken after 1 week.
Okay, on the prayer of MS
P day.
P. Day, learned counsel for the petitioners. Comma. The case be listed after 1 week.
Thanks to you.
For motion item number 1. My lord, item number 1, we filed affidavit, my lord. That may be called for the record. And in fact, my lord, that is this matter regard to pre-deposit, my lord, condition precedent. My lord, I got some judgment, my lord, for waiver of that pre-deposit, my lord. Waiver of pre-deposit, my lord. Lordship will give.
Waiver.
Waiver. my lord.
Okay.
Lordship will give. me
Okay.
waiver.
This is a statutory condition.
Yes, yes,
Right. See the judgments,
yes. I,
statutory conditions
right.
cannot be diluted in exercise of power under Article 226 and not even under Article 142 by the Supreme Court. Supreme Court has said once interim order was passed
My lord.
on a statutory condition, then when matter was heard, then said that we were wrong. Even under 142, we cannot dilute a statutory condition. And moreover, you find out new tech,
New tech, I'll find it, my lord. Lordship will give me some more time, my lord, to.
new tech.
To
We
master.
can issue, we are keeping this in motion. We will not keep it this at motion, but no interim order. Maintainability,
My lord.
stroke entertainability kept open will be considered on the retardable. But
My lord.
there cannot be. And find out one more thing.
My lord.
Where is the order in appeal?
That is my.
Sorry,
lord,
order in original.
Order in.
Order in original
Page,
or order in appeal?
page 71, my lord.
Order in appeal.
Page, page 71, my lord. Operative portion is.
No,
page
order in
97.
appeal, order in appeal.
Case 71.
Page 71, operative portion, page 97, my lord.
9. And let's see the original part. It starts from. This was passed under section
Section, my
35,
lord.
35 or
35.
F.
35
F.
F or 86, 86.
Yes, under Finance Act.
85 or 86. Service Tax Act.
Service tax, service tax.
Let us see. 73. "73. In any other case, the appeal shall lie under section 86 of the Finance Act to start within 3 months from the date on which the order sought to be appealed against is communicated." Right? When it was communicated to you? Any idea?
My lordship, it was passed on 17/5/2023.
17/5/2020.
Yes.
And when did you file this petition?
We filed this petition, my lord, 31st July, my lord.
Hmm?
31st July, my lord.
Not 31st, 5th. What was the limitation period otherwise?
That is 3 months.
Within 3 months.
3 months.
Okay. Heard. Mr. J. Roy, Lionel Senior Counsel, assisted by M. Borosai, Lionel Counsel for the petition. MSK. Who called? Lionel Central Government Council for the respond number 1. Mr. S.C. Kyle, Lionel's pending counsel,
GST.
GST
234.
234. And Mr. A. Sharma, Lionel Counsel for the respond number 5 and 6. 5 and 6. The petitioner. And SSC under the Finance Act.
No.
1994. Was served
Page 36, my lord.
is 36. No, where is the so-called notice?
That is the Shukos notice, one.
36.
36. Demand come Shukos notice.
Was served with a demand come so-called notice dated 29/9/2020. Asking him to show cause as to why service tax amounting to 1,46,41,544 on the services rendered during the period from financial year 2014-2015, page 39, 15 years. Within bracket October, 2014 to March 2014, bracket close. To financial year 2017-2018 should not be demanded and recovered from him under the proviso to subsection 1 of section 73 of the Finance Act 1994 as amended, plus interest and penalty, etc., under the other provisions of the Finance Act 1994. Full stop. Did you reply?
Yes. Yes. Reply is, my lord, lordship will see page 41, my lord.
Page 41. Okay. In response to the said demand notice, the petitioner as the SSC, demand comes to submitted its reply on
25/1 to 21.
and what did he say?
We say that the complete demand
Oh,
has not
no,
been,
no,
my
no,
lord.
no. What did he say about receipt of
Receipt, my lord,
reply? Hmm. Or, submitted its reply dated 25/1/2021. Post of the adjudicating authority as mentioned had mentioned in his the it is stated by the adjudicating authority that the said reply was received at his office on 12th to 2021. Full stop. The order in original was passed by the adjudicating authority on 31/5/2022. Full stop. Which statutory provision required deposit of pre-deposit?
Section 35F of the Central Excise Act.
35 central excise table আছে নি? জানো? Okay.
Page 97, it is been quoted.
As an appeal against the said order in original lied before the commissioner, custom and central excise within bracket appeal within a period of 60 days from the date of communication of the order in original, comma, the petitioner preferred an appeal before the appellate authority. Post of the appellate authority. Pass the order in appeal on 17/5/2023. Recording that the petitioner appellant did not make payment of mandatory pre-deposit at 7.5% of the amount in dispute while filing the appeal under section 35 of the Central Excise Act 1944. Full stop. Stating that such deposit is a mandatory precondition for filing an appeal under section filing an appeal, comma, the appeal was not entered in for any decision on merits. Full stop. Agreed by the said order in appeal dated 17/5/2023. The petitioner has preferred the instant petition under Article 226 of the Constitution of India, which has been registered on 5/8/2023. Full stop. Where one of the issues which have arisen for consideration. Some of the issues which have arisen for consideration is whether, firstly, whether the writ petition can be entered in when the petitioner did not prefer statutory appeal before the Customs, Excise and Service Tax Appellate Tribunal. Secondly, if the writ petition is entertained, whether this can entertain consider any issues on merits when the appeal was not entered in due to non-deposit of as the petitioner appellant did not deposit. Did not fulfill the condition of mandatory pre-deposit at the time of filing an appeal. because it did not merge. The appellate order and that order in original did not merge. Answer that question. All these factual things
Yes.
is not going to be considered.
Right.
Because suppose on limitation, it is not entertained, then original issues remain dormant. It will not be
I understand.
considered. Now, whether we can relax this mandatory precondition,
Right. I'll adjust that, my lord.
issue notice returnable on. When Mr. Kyle,
Any day, Lordship, because the law point,
only law point, we'll try to get it as early 29,
not,
Thursday,
not.
29 February. Can it be a date next to that? Any date after?
next to that.
4th of March, my lord.
4th of March?
Yes, Lord.
Okay, 4th of March. As soil to appear, accepted. No formal notice, extra copies within 2 working days.
Much.
Okay, Lord.
All right.
Item number 2.
May I please?
Yes, Lord.
Freezing one and notification.
Huh?
Freezing notification one.
PG.
Freezing.
Where then?
Hold on, there's no one belonging to petitions. But you could be the central media. Purpose of filing. National Highway number. Yes.
Instruction was for you.
Para 6 and 7, my lord, relevant. Para. We need to file affidavit on.
So what is coming out of this instruction?
I could not understand. I could not even understand.
And my lord, from my side, when I say detail I'm appearing, 5 to 9, I have received a detailed perverse comment. Here I have, under preparation of it, but here is categorically it has been stated that regarding acquisition of land, my lord, I made it on the 4 lines. In this regard, it will be submitted that NSIDCL has not occupied private land of the petitioner. Neither the balance work of highway has been executed at this private premises till date. it may be kindly noted that any additional required land will be occupied by NSA edition only after following due procedure of land acquisition as per NSA 1950, meaning thereby, so far we have not acquired the land and no construction is carried out by this affidavit. Whereas comment has come to me. And this regard, I file affidavit. 10 days.
Then don't do anything with his 1 bigha.
No, we are not doing
1
it.
kara 10 lesa.
We are not doing anything because we are not occupied. Who will do me?
Or Mr.
UK Deka.
CK,
UK Deka.
UK Deka, Land Council for the petition and board of standing council revenue. Just that, 5/1/2024 order to Lucknow. MSM Bormon 2 to 4. Mr. C. Borua,
5 to 9.
Standing Council NHIDSL 5 to 9.
My lord.
5/1/2024 to second parallel. On 5/1/2024, Learned Junior Government Advocate Assam and Learned Standing Council NHIDSL were asked to obtain necessary instructions in a matter. MS Bormon has submitted that as per the instructions received from the office of the respondent number. Is Kala or what? MS Bormon, he is Kala. Competent authority.
And
Respondent number 3.
Respondent number 3, my
Three.
lord. Competent authority.
Respondent number 3. What is your DAG number? In Dibrugarh district?
Lordship.
What is your DAG number and
Dag number 186, Pata number 41.
40? So 0.040 hectare amounts to what?
It is 6 lessas, your lordship.
Huh?
6 lessas has already been acquired, your lordship, and compensation has been paid, your lordship. Later on, your lordship may kindly come to
Petition, it is mentioned in court.
Annexa is page 54, your lordship.
MS Bormon,
My lord.
please see Annex 3 of your instruction.
Sorry, my lord, I have got it.
Oh, oh.
This is the second copy.
Or whether this is available. 11/10/2021 letter in the repetition.
No, my lord.
No, lordship.
You see this one. Both of you read this one. Mr. Borua also. I don't know what is correct, what is not correct. Initially 4 lessons.
Yes, my
Then
lord.
please. Later on.
In addition to 4 lesser, 1 quota 10 lesser was
In addition, he says.
additionally. my lord.
Then again he says, in the parawise comment,
Yes, my lord.
no
No
acquisition.
acquisition was done. That
So
is
what?
in 5 and 7.
What the
Paragraph
court
6,
can do?
6 and 7 is contradictory, my lord.
Huh?
6 para reply in para 6 and 7,
Ah,
my lord, it is
What we
contradictory.
can do? We are not on the ground.
Yes.
Circular which are always taking forward. These are circular which are And generally we are saying they don't tell you.
It is document. He says different thing.
Yes,
And the parawise comment, he says
Different.
different thing.
today
I
morning I
think
got this, otherwise I
they
could
are
not get
the
any clarification.
source of
on-
trouble.
Yes, my lord, to an
Eh,
extent.
Initially, your lordship, they were refusing that any additional land is acquired, your lordship. Only after your lordship, because of this honorable court, your lordship, they have accepted that additional one.
Whether you are the owner or not,
Lordship.
there may be many owners.
Yes, yes, your lordship. But yes, your lordship, I am one of the partner, your lordship. Family members are there, your lordship, but they are not residing there.
Huh?
My house is there, your lordship.
Your house is there, but they may be patadars.
Yes, yes, your lordship.
Or they have received money.
No, 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 no.
Affidavit will file, my lord, affidavit will
Huh?
be clear because I have also received detailed affidavit I have received. Only I have gone for only two paragraphs. That is why I may be also wrong sometimes. That is why by way of affidavit will come to your lordship after 10 days, 10 days after that.
Two
After
weeks.
10 days will
2
come, my
weeks.
lord. If at all,
Right, but if I can untie something, it will be better for me on the next day.
My lord, because I need
That
to
is why
clarify-
I'm
I
make an
need-
exercise initially. So what is the trouble?
yes.
Yes, but that instruction is not adequate enough. sufficient
Yes,
enough to
even
follow.
out of these instructions, whether we can extract something or not, that is what I'm trying.
প্ৰব্লেমবোৰ পৰে চাব গৈছে ই এটা এই আমাৰ যিটো মেচিন ইমান পটককৈ তুমি লৈ আহিলা না নেক্সট নাইট লৈ
He has admitted in the parawise comment, paragraph 6, that petitioners, one kata 10 lesa was acquired.
My lord.
In addition to the petitioners, land measuring 4 lesa. What he has denied is that
He has no
did
right-
not acquire 1 bigha 4 kata 2.5 lesa of the petitioner's land. It was not the petitioner's case.
No, my lord. His case related to
His
4
case
lesa
was only that
4
1
lesa.
kata 14 lesa. 4 lesa earlier
Earlier.
acquired, now
Now
remained
1
1
lesa.
kata 10
10
lesa.
lesa.
That is his case
That is not-
consistently.
Yes, ma'am. That is not answered. properly.
That is not answered. No, he answered. Answered.
Contradict-
During the said survey of the land, it was found that a piece of land measuring 1 kata 10 lesa was acquired by the authority.
My lord.
In addition to the petitioner's land measuring 4 lesa, which was acquired earlier. Right? Now what he has denied?
No big deal.
The circle officer accordingly submitted his report dated 11/10/2021 to the ADC LA, Dibrugarh. In the premises, it is denied that the authority acquired 1 bigha 4 kata 2.5 lesa of the petitioner's land. It was never the case of the petitioner.
No, my
Let us see 8 and 9. They create difficulty. You have also created some mess in para 8. 1 bigha 4 kata 2.5 lesa. Where from you have got? Paragraph 8, last 3 lines. You make a claim here and there, vague claim, throw it to the court. Paragraph 2, you have said that tag number 186, 3 bigha 3 katha. Then in paragraph 8, you say 1 bigha 4 katha. Then you say 1 katha 14 lesa. Then you say 1 katha 10 lesa.
Total land is there 3 bigas 3 less, your lordship.
Then
In the Doug number 186 of Pata number 40, your lordship.
uh,
Out of that, your lordship, 4 less has already been acquired. Compensation has been paid, your lordship.
right.
No.
Why you have mentioned paragraph 8, 1 bigha 4 katha. 2.5 lesa.
Not having any nothing.
Sorry, your lordship.
What is your reason
It should be
for
one
making such
one
a statement?
No.
The mess is created by you, confusion is created by you. At one point of time, you are saying 1 katha 10 lesa, they are going to acquire or they have acquired. Then how come this 1 bigha 4 lesa, 4 katha? That's for instruction, no? 1 katha 10 lesa. Petitioner's land. Sorry. A parcel of land measuring 1 katha 10 lesa has been acquired by the authority under covered by tag number 186 and belonging to the petition. Equivalent, no? In addition to acquisition of petitioners land measuring. In addition to earlier acquisition of the petitioner's land measuring 4 lesas. First off, Mr. Burua, Standing Council, NHIDC, has, however, submitted on the basis of the instructions he has received that the NHIDCL is not in the process of acquiring any parcel of land measuring 1 katha 10 lesa under DAG number 186 and belonging to the petition. As the instructions received by the Learned State Council and the Learned Standing Council NHIDCL are found to be at variance to one another, the respondents shall file their counter affidavits to bring out the true state of affairs, real state of affairs. Issue notice returnable on. Oh. Martha Dito.
6-3.
As so and so
6-3.
appeared. So and so, so and so. No formal notice. Extra copies
Did him-
2 working
did
days.
him.
By Monday, your
There
lordship.
failure returnable date. It is provided that there shall be status quo as regards. One Katha tells us covered by Dagdamba. One 86 and Pata number 40. In respect of the plot of land measuring so and so, covered by so and so, situated at Dikhori, Nepali Gaon, Moja Moran, district, Dibrugarh.
Right.
Then only they come up with.
Is
When a national
highway.
highway authority puts pressure, then central government puts pressure, they would then come up with
Yes.
actual state of affairs.
I don't read.
May I please, your lordship? Lordship, this is on contempt petition, your lordship. Order dated 11/9/2023, your lordship. Pass in WBC number.
Heard, SI Planet Council for a petitioner. Instant contempt petition. Instant petition under so and so. Is preferred. Alleging. Willful. And deliberate. Violation of direction. Given in the order. Given in an order dated 11/9/2023. In the writ petition. WBC number 6941/2021. Post of the petitioner has averred that the order dated 11/9/2023 was duly brought to the notice of the respondents. Post of issue notice returnable in court. Steps by register post VJD within 3 working days.
Deeply.
Item 4.
Contempt petition, my lord. Lordship will find the order at page 8, my lord. In the operative part, the lordship will find at page 10. my lord.
What? Hearing that was not fixed.
The hearing date was fixed, my lord. He appeared thereafter, my lord. I was asked to furnish explanation, my lord. I furnished explanation on 10th, my lord, 10th of July. Thereafter, my lord, nothing has happened. I represented
Okay.
them, yes,
Okay, dispose of the matter within an outer.
yes, my lord. 1 month.
Heard Mr. M. Odhikari,
Yeah, my lord.
M.R. Odhikari, Land Council for the petition. Particularly order to go 36/2023, WBC number 3880/2023. The order was duly brought to the notice of the respondents. Issue notice returnable 4 weeks. Did not comply, Mr.
But, the.
Direction was made specifically to whom?
Yes, district registrar,
District registrar. Then why you are making all this?
because, my lord, he is under them, my lord.
Ah,
Number
he is
six,
the
number
competent authority. He is the authority,
Yes,
licensing authority,
yes.
who has the power to
yes,
cancel,
Yes,
who has the power to restore.
my lord.
Then we'll issue only notice to him. Which one?
Fine.
Which one out of that?
Three,
3 or 2?
2, sorry.
2?
Yes, district commission.
2.
Yes.
Only 2.
A little bit 2 and 3, my lord, because the matter is pending with 3 now.
Direction is to whom?
To the district registration, that is ADC, my lord. Three,
See,
yes.
so two. We don't know who has here, he has to pass the order,
My
who has given a direction to him.
My lord.
Now he will be after three. Give the order, he will say,
My lord, obliged,
once he is put to notice.
my lord. Obliged.
Item number 6.
May I please,
Your Lordship, on the last occasion, I have been directed to bring the details, instructions on the nomination of the
nomination.
petitioners.
Yeah.
Your Lordship, there is some doubts and we have not found the nomination form that has been deposited. And that is the main problem to us.
Whether in the, I think you maintain electronically everything,
Yes, Your Lordship.
whether his name is reflected there,
Yes,
in the record,
yes, it is not there, Your Lordship.
not record, in
And
the system not there.
yes, and what was happening when he has presented with his application in the branch has asked him that to bring the family, that he has mentioned that in his relation he is a family member, but actually he is not a family.
No, who has
member.
submitted the nomination form?
Yes, yes, for that I.
If the bank account holder has submitted the nomination form, that is a different issue.
Yes,
The
He has
nominee
to-
may not be relation, maybe son, maybe daughter, maybe distant relative, maybe a neighbor also,
yes, sir.
Yes.
or a person who is taking care of the account holder.
Yes, sir.
Maybe at the old days. If the bank account holder submits the nomination form,
That form.
that
he-
is altogether a different issue. But if the petitioner is submitting the nomination form himself,
Yes,
that is completely different issue.
yes, Your Lordship. That is.
So that is what I try to inquire from you.
A short
Whether
time may be
this
given.
diseased account holder,
Yes, both the deceased, Your Lordship.
both the
husband and wife,
deceased.
Both are deceased.
whether they had submitted the nomination.
Yes, sir.
If they had submitted the nomination form,
Then there is
then
no issue.
there is nothing for you to doubt,
Yes, sir.
Yes, sir.
right?
Yes, sir.
But if he had submitted, then it is a case of doubtful,
Doubt.
right? That is what.
Yes.
My lord, as per instruction, my lord, this lady.
Your
filed a-
instruction is not do, the record should reveal.
Let them produce the record. my lord.
Then we'll issue notice. I tried to expedite the matter.
Yes,
Mr.
sir.
Sharma has come up with no instruction.
Your Lordship, 1 week may be given, that will be.
We just want to know that if the
I understand your.
account holder has submitted a nomination form, then there is no authority for you to doubt.
Yes, sir.
I think law says that if the amount is disbursed to the nominee, then that is a valid discharge perhaps,
Valid discharge.
on the part of the bank.
Yes, sir.
And you will definitely obtain indemnity bond for
Yes,
that
definitely.
perhaps.
Yes, my lord.
So that is why I have asked. But we will not like to keep it pending every time.
Let him to take instruction another week, my lord, without,
Your
may not
Lordship,
be soon.
one last chance may be given for that.
Because it is DS Road, Ulubari only.
Yes, it is nearby. Uluvadi.
Okay. Heard Mr. Jivuddin, Learned Counsel for the petition, and Mr. M. Sharma, Learned Counsel for the respondent bank post of Mr. Sharma has submitted that he needs further 1 week time to obtain instructions regarding nomination details of the petitioner. Post of the Mr. Sharma shall obtain as to whether it was the account holder who had submitted a nomination form. As thought for Mr. Sharma, raise the case on after 19 of the
21.
21.
Hello.
Obliged.
Lordship, as per last order, instruction was sought whether Lordship Kala has decided the dispute regarding apportionment of the award.
National Highways Act. Tell me what is the sum and substance of this?
Petitioner has sold out his portion, my lord. Petitioner has sold out his portion as per this instruction, my lord. So they are negating the entitlement of his claim.
Negated. Petitioner stated he is the owner of a plot of land measuring 2 acres, 1
Lordship,
kata,
it's
12.5 acres
para
covered
three.
by Dag number 30, but the situated ward, Goripur Revenue. It is a part of the subject of measuring 1 acres has come to be acquired by the Ministry of Road Transport and Highways, Government of India. Under the provisions of, according to the petition, dispute is arising in the apportionment of the award as pursuant to the so 1 bigha, 1 kata, 5 lesser.
Yes.
Okay.
Beginning. Yes, sir.
Mr. Council,
Yes.
award number 385
Yes.
was already prepared
Yes.
and assessed. Your DAG number 30 and pata number 51 or 50?
Lordship, I have stated, this is Lordship.
Whether I recorded wrongly.
Yes, yes. Yes.
I recorded wrongly.
Yes, yes. On record.
I recorded wrongly.
Yes.
Okay, I recorded wrongly.
Petition 51.
Your name is what?
Moksed Ali.
Moksed. File counter affidavit.
Mine.
If things stated here is correct,
It's correct.
then the petitioner should approach under TH4.
That's correct.
And to observe that, we need the counter affidavit.
Now,
Fine.
here, only my submission is this one.
We have no business here.
No, here, because only 1 minute. He has made me NSA also, NSADCL also is a party, but here a instruction he received, his particular route area has been not contacted by neither NSA nor NSADCL. That is by PWD and his division. That is why if at all payment or whatever it is to come up, have to come for.
File the affidavit for non-joiner, will decide.
But both had
File the affidavit.
or
You have received the instruction
stacking
that you are not the acquiring authority. MS Bormon has received the instruction to file the affidavit. Both of them file.
Yes.
Then we'll say we have no business.
Well, my
Here,
intention
if the petitioner has sold his land, let him fight it out before the proper authority under 3H4.
Yes, civil court lordship. Exactly.
Whether wise sense will prevail upon you today or after 2 years, it is up to you. We are not here. We'll decide the repetition only.
Yes.
AJ Ahmed, Learned Council for the petitioner. MSK Fugan, Learned Central Government Council for the respond number 1. Mr. C. Burwal, Learned Standing Council, NHAI and NHIDCL, appearing for the respond number 2 to 4. And MSM Mormon, Learned Junior Government Advocate Assam for the respond number 5 and 6. Both Mr. Burwa and Ms. Bormon have submitted that they have received the necessary instructions to file counter affidavit on behalf of the respondents represented by them. They have sought for
3 weeks.
3 weeks time to file such counter affidavits. First of the claim made by Mr. Burwa and Mr. Gussam MS Bormon is allowed. Release the case after 3 weeks.
Lordship, kindly my one date may be fixed, otherwise.
We don't find anything to give a fixed date. Go through your
Yes.
Parawise comment, which has been obtained by MS Bormon.
Yes.
Go through it.
Okay.
The report says that you have sold the land,
Yes,
maybe,
that is
and
why
there
lordship- that is why
no
lordship-
dispute.
Yes, yes. That is
Don't
why.
make submission.
Yes, yes.
Don't make submission.
Yes, yes.
And the other party is in possession of land for 3 years to 3 years,
Yes, yes.
right?
Yes.
And everything gives rise to disputed questions of fact,
Yes.
which in a writ proceeding cannot be decided.
Yes, that is
So
why.
you go through it, then take your own call. When the time to take a call
No, lordship.
is
I'm
available,
exactly-
we'll take the call.
Exactly not that one, lordship. So I, lordship, refer the matter to the lordship.
I'm not
civil court.
reverting.
No, lordship, direction may be given.
I'm not reverting anything. I decide the repetition. Let them come with counter affidavit. If you want to approach, it is up to you.
No, no, lordship. Otherwise.
Please have the counter affidavit.
Item 10.
Yeah, please, your lordship, limited prayer in this petition, lordship, in the year 1980, lordship, the blazer of Dekasuk and lordship Godadar Mara.
Lordship, my learned friend, my lord, the petition is not maintainable. My lord, they say that it is a, my lord, that is a Samavai Committee. Whether it has been registered or
No,
not.
no, that is a
And
let.
even then they have
let
did
me-
not, my lord, they submit the.
No, 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 my claim is not
court
that,
fee.
lordship. Let me allow to submit, lordship. Lordship, the petitioner number 1 is a society that is not a registered society that has been formed by the other petitioners, lordship, and the as well as the people of the two blazes. One is Dekasuk and next one is lordship Godadharmara of Jamugurihat. Lordship, in the year 1980, lordship, when there was no employment for the educated young generations, lordship. In that time, lordship, the resident of the two blazes thought that, lordship, it will be better for the all the blazes, lordship, blazers, that they will engage the unemployed young generations in cultivation, lordship. Because within two jurisdiction of the two blazes, lordship, 36 bighas of unused government land that is laying in within their jurisdiction.
Who is what is the under what class that land is recorded?
Lordship, foreign to land, lordship.
Sita?
Lordship, since it is a
Sita?
government land, lordship, we have only we paid
Sita
only,
Gobi?
lordship, since it is a government land, Lordship, we have only
Because
paid
you say.
land revenues, Lordship.
You say you are from some villages.
Yes, your Lordship will find at page number
No,
Uh,
I'm just. asking.
26, your Lordship, because we have
You are all
paid
residents
revenue,
of-
Lordship.
You are all residents of
Lordship, Dekarsuk and
Godhamara.
Godadharmara.
Godhamara.
Yes, your Lordship.
And
Dekarsuk, Lordship, your Lordship will find at
Ah.
paragraph 2, Lordship.
Godhamara and
And Lordship, Dekasuk, Jamuguri hat, Lordship. We have,
now.
we are not claiming, in fact, Lordship.
You are not claiming.
Personal
Okay,
purpose.
okay, Mr. Sharma.
Yes, your Lordship.
Now, just a glance at your translated copies from Annexer 2.
Yes, your Lordship.
Just the name. Gwalgaon.
Yes, your Lordship. It is a revenue place.
Gwalgaon.
Yes, your Lordship.
That
Nodwar,
might have indicated something. So, show me the Sita.
Lordship, so far the Sita part is concerned in the government land, Lordship. We are not allowed.
Generally,
in the
something
Sita,
is
Lordship,
also recorded.
in the Sita. Lordship,
Sita.
I may be allowed to.
Sorkari.
Yes, your Lordship.
Sorkari.
Yes, your Lordship.
And something more.
This is a Sarkari Lordship, Axona, that
And something more.
it may be Lordship.
If that something more bears immense significance.
That may be Lordship in the Sita, that may be, we may be collect the Sita Lordship. At this time, my
That-
prayer is only to
That
that.
comment might take us to 2011. Jokpal. The name of the village itself indicates something.
Lordship, this is
So why don't you bring the Sita copy?
Lordship, I may be allowed to collect the Sita copy because this is a revenue place. Gwalgaon is a revenue place. Under this revenue place, there may be 2 or 3 villages. There may be 2 or 3 villages because,
All are in Gwalgaon.
yes, your Lordship.
All are in Gwalgaon.
Under Nodwar revenues,
Somebody who is collecting,
Lordship,
Mojada is collecting.
That Toji
revenue
fine.
is collected.
Toji fine, Lord.
Where is
No,
Toji?
not
Lordship,
Lordship.
Kalesida place, Baladet, Baladet, vernacular.
Who pays?
This
Show
is
me
not a
show
Toji
me the
vendor.
page.
29, my lord, that
29.
is a
Okay,
Toji,
let us.
Toji 194.
Kuntu?
This is Ato.
Ato,
Ato.
Lordship.
Mojada is giving receipt.
Lordship,
Show me some other
Lordship, I may be
other
allowed.
government documents.
Yes, your Lordship.
Mr. Sharma, please show me some
Lordship, since.
to proceed further.
Yes, your Lordship.
At least
I appreciate Lordship.
You might be quite satisfied with it, right?
It's correct, Lordship.
At the same time, I should get myself satisfied.
Correct, Lordship.
Is it not?
Only my.
Mojada's document
Yes, your Lordship.
collecting Toji Bahira revenue
Yes, your Lordship.
is deemed to be illegal as per
Lordship,
by the Supreme Court in
Lordship,
I don't know.
no,
no. Okay.
Lordship.
Leave aside.
Yes.
Leave aside that. You have not made the homework.
Lordship,
Okay. Next. Show me the Sita.
Lordship, only my humble submission before.
No,
the
show me the
Lordship,
Sita.
Lordship, that since.
Mojada's receipt,
Yes, your Lordship.
all these does not go to prove anything.
Yes, Lordship.
Right.
That is why, Lordship,
Right.
my humble prayer before
No,
this honorable court is
If
that, Lordship.
it do not go to, they do not go to prove anything, it indicates that you are amateurs.
Lordship, yes, definitely.
Unless
Yes,
you show me
yes.
something to rebut that opinion I have formed private side.
Lordship, a short time may be allowed, Lordship. I will
Even then, my
collect
lord, the court fee, they did not serve.
Huh?
There are several.
Court fee also.
Lordship, my lord, can you see the? Lord, they have if my lord, that it is not what treated as a, my lord, that society,
Lordship,
that they have several.
How much?
Lordship,
There is no court fee or what?
Lordship, our claim is not
Yes,
to,
yes, isn't it?
not to settle the land in our.
When then, my lord, they have approached this honorable court, my lord, the filing this writ petition, but they have to file.
Do you know about
Lord, I did not find, my lord, that in the period. There,
it?
are,
In the, in the,
second petition also.
80 petitioners.
No, not even a single rupee,
Not that kind of.
Lordship, I.
electronically paid, or what?
No, Lordship, I'm very sorry, Lordship. I have projected in
Oh.
this case, Lordship, that I have
10
not paid
rupees,
for
10
settlement.
rupees, 10 rupees, 60. 60 rupees. Registry to verify whether proper, the instant repetition is preferred by 80 number of petitions. Full stop. The registry to verify whether proper court fee is paid or not.
Lordship, only my.
And thereafter, submit a full stop, registry to verify as to whether proper court fee is paid at the time of filing the writ petition. Also place the case after a week with a report as regards payment of deposit of court.
Lordship, for a moment, your Lordship may kindly see my prayer. My prayer is not relevant to
First,
Lordship
we will ascertain.
claiming for settlement, Lordship.
We are,
I am not
whether
claiming-
High Court rules says that for settlement, this much of court fee, allotment for this much of court fee, whether High Court rules have distinguished something.
Lordship, no, I am,
Oh.
my,
No.
that I will, your Lordship will, if your Lordship will permit, I will pay accordingly, Lordship. Lordship, only my humble submission is that in my writ petition, I have projected only that if, since it is a government
Next
land,
case.
this land may be protected as a Lordship allotted, Lordship gauging land, Lordship. That is only my humble prayer. Hello.
Lordship, I appear for the petitioner virtually, Lordship. I beg to appear virtually, Lordship, in item 13. Lordship, last day, learned counsel for the department had sought that whether notification can be heard by our Lordships, challenge to notification. Lordship, I would like to rely on one judgment of your Lordships passed last Friday, wherein the subject matter was a circular challenge and a show cause. And your Lordships has given a stay.
Mr. Kanodia,
Lordships.
I was quite aware of it. A circular is not in the same status as notification. Right? Otherwise, there is some distinction I find. So that is why I think I consciously said it.
Lordships.
Circular. And not a notification under perhaps section 11. Is it not?
Lordship, our case was 168A, the force majeure notification, Lordships. Whether in 2023, the event of force majeure was present for the department to extend the timelines, Lordships.
No, Mr. Kanodia, here the question is, if a challenge to a notification is made,
Lordships.
then according to Mr. Kayal,
Lordships.
that it should be placed before the division bench.
Lordships.
That is what his submission is. So,
Lordship,
respecting that submission, Mr. Kanodia, respecting that submission, I thought it proper to.
Lordship, I vote on your Lordship. I vote on your Lordships on that. But Lordships, in fact,
No, you don't make additional submission.
No, I'm not making any additional submission, Lordship.
So,
Just
where is Mr. Kayal?
Let-
Kayal is not available right now.
Lordships.
We'll call it after some time. Whenever it is called, your assistant counsel will inform you.
Lordships, I am waiting virtually.
Right?
Grateful to your Lordships. Grateful to your Lordships.
Kayal pare mati dibo po. Inform Kayal, Henry. Mr. Henry, try to inform Kayal.
Item number 39.
Yes, what do you think?
May I please? I've got a judgment, my lord, perhaps that will be lodged.
Land giving. Judgment means.
On the Milord, whether it will be 226 or 227, my lordship was asking this question.
What is your view?
In my submission, will be 226, my lord. Because though, my lord, it's a order, my lord, on the civil side, but it's by tribunal, not by court of my lord. That way.
That is what. Now, then we have to make, since you are submitting that, we have to make a longer analysis. Now, land giving it. Special tribunal, section 7.
Yes.
Appeal, my lord, is before section 13, I think.
Mr. Henry, don't make submission. You have not constituted any
Sorry, Lord.
appellate court. It is due to non-constitution of tribunal by you, we are dealing with the matter. Tell us that, yes, we have a tribunal, we have constituted. I asked the same query to the learned advocate general, learned additional advocate general. Yes, what has come out of that earlier proceeding? That was not listed before me. Firstly, Mr. Goswami was there. Then learned advocate general also appeared.
My lord,
Then I asked few queries.
my lord.
Then the matter was not listed before me.
Right.
I don't know what happened in that case. If that is admitted, we will simply admit. What happened to that case?
Exactly, I don't know, my lord, that in respect of that.
Because similar question I
Uh,
asked Mr. Goswami. Also to the learned advocate general. Because I have some doubt. Okay, read paragraph 6, section 7.
my lord, yeah. There shall be a special tribunal for the purpose of inquiry into an alleged act of land grabbing and trial of cases in respect to the ownership and title or to or lawful possession of land grabbed.
Right. This is one part.
It is one.
Now, next part is important.
And the court of district and session judge having jurisdiction over the area shall be the special tribunal for the purpose of this act and shall include additional district and session judge having jurisdiction of the area.
Right. This has been entrusted to a pre-existing,
Yes.
because I have read one judgment, that is why.
My lord.
This authority, judicial forum
My lord.
is pre-existing.
My lord. That's good. That is it.
And that includes
My lord.
additional district and session judge.
My lord. My lord.
Meaning thereby, it is not a persona designata, that one particular person, like an arbitrator in National Highway Act.
My lord.
This man
My lord.
will only decide, say, hypothetically,
My lord.
but here it is by the particular forum, and which is pre-existing,
Right.
right? Then, 8.
Every special tribunal shall have the power to try all cases arising out of alleged act of land grabbing or with respect to the ownership and title to or lawful possession of the land grabbed, whether before or after commencement of this act.
Hmm.
The special tribunal may either suo moto or on application made by an aggrieved person or an officer authority take cognizance of and try every case arising out of an alleged act of land grabbing or with respect to the ownership and title or to or lawful possession of the land grab, whether before or after commencement of this act, and shall pass such orders, including orders by way of interim directions as it befits. The special tribunal, for the purpose of taking cognizance of the case, consider the location or extent or value of the land alleged to have been grabbed or the substantive nature of the evil involved in the interests of justice required and any other relevant matter involved in the case. Provided that the special tribunal shall not take cognizance of any such case without hearing the petitioner or the aggrieved person as the case may be. Notwithstanding anything contained in the Code of Civil Procedure 1908 and the Code of Criminal Procedure 1973, any case in respect of an alleged act of land grabbing or the determination of questions of title and ownership or to lawful possession of any land grab under this act shall be subject to the provisions of this act to be triable in the special tribunal. Provided that if it is in the opinion of the special tribunal, any application before it is prima facie frivolous or vexatious, it shall reject such application without any further inquiry. The special tribunal shall by notification.
This is regarding notice part.
Notice part, my lord.
Next.
Next, my lord, the cause of notice, my lord.
Six.
Notwithstanding anything contained in the Code of Civil Criminal Procedure, and it shall also be lawful for the special tribunal to frame charges and try all offences punishable under this act. If in the opinion of the special tribunal it is so necessary, after delivery of its decision on order in the
Order in the civil liability.
where prima facie it appears to the special tribunal that a particular person or a group of persons are responsible for commission of an offense of land grabbing punishable under this act.
So on the exercising civil jurisdiction, it will decide about the civil liability. And plus, it has been given the power, like the criminal code,
Yes.
as in CRPC, to frame charges. This is, I think, the purport and object
Yes.
of this provision. Let us read further.
Every finding of the special tribunal in a trial under this section with regard to the alleged act of land grabbing, ownership and title to or possession of the land grab shall be conclusive proof of the fact of land grabbing, and the person who committed such land grabbing and every judgment of the special tribunal with regard to the determination of title and ownership to or lawful possession of any land grab shall be binding on all persons having interest in such land. Every case under subsection 1 shall be disposed of by the special tribunal as far as possible within a period of 12 months from the date of institution of the
Please,
case.
time limit.
Time limit. Time limit. my lord.
Next,
Then, my lord,
nine.
my lord, it shall be lawful for the special tribunal to pass such orders as it may deem fit in the interest of justice. It will award compensation in terms of money for wrongful possession of the grab land, which shall not be less than an amount of equivalent the market value of the land so grab, and as on the date of the order, and the profits accrued from the land payable by the land grabber to the owner of the grab land, and may direct redelivery of possession of such land to its rightful owner. The amount of compensation and profits so awarded and the cost of redelivery, if any, shall be recovered from an area of land revenue in case the government is the owner, and as or as a decree of civil court in any other cases. It may impose such punishments to the land grabber for commission of such offence punishable under this act.
Now, 9.
9. The special tribunal to have the powers of civil court and the court of session, save as expressly provided in this act, the provisions of this Code of Civil Procedure and the Code of Criminal Procedure 1973, in fact, in so far as they are not inconsistent with the provisions of the act shall apply to the proceedings of before this special tribunal, mutatis mutandis, and for the purpose of the provisions of the said enactment, the special tribunal shall be deemed to be civil.
Shall be deemed to be
a civil court,
civil court,
or
as the case may be,
a court of session.
a court of session.
Right.
And then shall have
all the powers of civil court and the court of session, and the person conducting a prosecution before the special tribunal shall be deemed to be a public prosecutor.
prosecution. If it is prosecution, then it will be
Public
prosecution.
prosecutor.
So civil court and
Yes,
court
ma'am.
of session.
Deemed to be a civil court.
Then procedure.
Procedure to be followed in a special tribunal, save as otherwise provided in this act. A special tribunal in the trial of a case relating to an alleged act of land grabbing, or with respect to the ownership or title to, or lawful possession of the land grab, or whether before or after commencement of this act, which involves civil liability, follow the procedure prescribed in this Code of Civil Procedure, and the trial case relating to alleged offense of a land grabbing involving punishment prescribed in this act, follow the procedure of Criminal Procedure Code.
So on the civil side means it is to be treated as a civil court.
Yes.
It will follow the procedure of CPC. And similarly, after that,
Criminal
can direct recovery of possession, can direct compensation. I think these are aside. Then 2, subsection 2.
After taking cognizance of such a case under subsection 2 of the section 8, the special tribunal shall try and dispose of the civil liability at first, and decide and pass an order as to title, ownership, and lawful possession of the grab land, whether before or after the commencement of this act, as it deemed fit.
So it is civil liability.
Civil liability.
First, civil liability.
Well,
we are dealing with a writ petition, which is with civil liability.
My lord, there are some, my lord, this order, my lord, says transgressive. I'll come to that, my lord.
If that is so, then it will be directly 227.
I'll come to that, my lord. After completion of the civil proceedings, if the special tribunal decides or passes order that the land in question has been grabbed, the special tribunal may order that the possession of land be restored to the person whose land has been grabbed after evicting the land grabber, or any other person who may be in possession of the land, if necessary, by use of force as be required for the purpose. Provided the execution of the order of the restoration of the possession of the grab land shall not be made till expiration of the period of appeal provided under section 13 of the Act. If within a reasonable time after the expiry of the appeal period, no order of stay or execution has been received from the special court or produced from before the special tribunal by any of the parties of the case, the tribunal shall proceed with for execution of its order and simultaneously frame charges against the land grabber to prosecute him for the alleged act of land grabbing. Now, here may I pause for a moment, since the tribunal has not been, the appellate tribunal has not been formed, it creates a lot of difficulties, my lord. Now, further, provided further that in the event of preferring appeal from the order of the special tribunal for the special court, where the stay of execution of the order has been made by the special court, the special tribunal shall not further proceed in the proceeding to prosecute the land grabber till the final disposal of appeal by the special court. Provided that after hearing the appeal, if the special court decides the appeal against the alleged land grabber, that event, charge for prosecution against the land grabber shall be framed by the special tribunal and proceed with the criminal proceeding for prosecution of the land grabber. Now, section 13 is the appeal matter. The special tribunal may prefer an appeal to the special court or any question of law and fact. Now, my lord, this, my lord, has this right, my lord, is non-existent as on date, my lord. And my lord, lordship will see, my lord, that it involves, my lord, quite a, my lord, the implications are very serious. It can not only lead to, my lord.
Now, let us see the operative part of the order.
Yes, my lord. My lord, the order, my lord, it starts from page 41, my lord. And my lord, the operative part, lordship will find at page, my lord, in fact, my issue number.
Page 52.
50.
Issue is a different thing.
Different.
But let us see the order is in
Yes, my lord.
conformity with the.
The respondents are found to be land grabbers as defined under section 2 of the act, and they're liable to be prosecuted for commission of an offense under section 4. For the petitioner shall be put to possession of the suit land of expired appeal period. That apart, the petitioner shall be compensated by the respondents for illegal possession of the scheduled land since 7 years, which is quantified at rupees 1 lakh. In the event of the failure of the respondent to pay, it shall be recovered from the areas of land revenue. Prepare decree accordingly.
So, which part of this is not in conformity with the act?
My lord, here, my lord.
Nothing. It is to be tested on facts.
My lord.
Otherwise, this part is not in totally in conformity with the provisions of the act.
My lord.
Firstly, he has declared the respondents to be land grabber.
Land grabber.
He is empowered to do so.
My lord.
He is the authority.
My lord, he can do so. My lord.
Then secondly, liable to be prosecuted for commission of an offense.
My lord.
Yes, he is empowered. Further, the petitioner shall be put into possession of the scheduled land. Yes, after expiry of the appeal period. Rightly observed. That apart, the petitioner shall be compensated by the respondent for illegal possession of scheduled lands since last 7 years, which is quantified at 1 lakh. He is empowered.
He's empowered. He's empowered, my lord.
In the event of failure of the respondent to pay, it shall be recovered from them as areas of land revenue. Everything he has done within the jurisdiction and authority vested upon him.
My lord.
Meaning thereby, it is the what are to be examined? The determination of issues.
My lord.
With the facts.
My lord.
Right? So, this part, what is your submission? What is your submission?
My submission, my submission will be first.
This will be a writ petition.
Writ petition.
That you have filed a writ petition.
Petition.
So satisfy me that a writ petition is maintainable.
Well, my submission will be, my lord, here, my lord, since.
Have you gone through the reference judgment rendered by division bench in land grabbing case of this court? Division bench in a reference case.
Division bench, my lord, I had gone through one, my lord, but this one I have not brought it, my lord.
It is by division bench of Honorable Justice U. Bhuiyan.
Yes,
and Honorable Justice K.R. Surab.
My lord, yes,
and the judgment was authored by Justice Surab.
My lord.
Going into the entire aspects of the land giving.
My lord.
Have you gone through?
I've gone through, well, but at this moment I'm not having it, my lord. Having it, my lord.
Did it touch upon anything about this?
My lord,
no, it
no,
was not.
I don't think, it was not. It was tough. It was,
what is your judgment?
It was a writ petition. The judgment that I'm referring to, my lord, is of, my lord, 2015, my lord, Supreme Court, my lord.
2015.
Supreme Court section.
Can you hand over a copy?
Yes, I'll hand over the book, my lord. I have 3269.
Because why I'm saying it is not a basically simple authority.
Right.
This authority is a civil court.
Well,
It is not that district commissioner.
no, well, it's a civil court, but then it is basically functioning as a tribunal.
So tribunal.
It's functioning
So
as tribunal. It's not,
tribunal does not come under jurisdiction of 227.
my lord. No, tribunal, my lord, my lord, paragraph 11, my lord. In dealing with the powers of the High Court.
Radheshyam.
Yes, my Radheshyam.
वो पैकेट वाला सर पैकेट
Because, my lord, in Surya Dev Rai, my lord, it was also even held that the court can exercise jurisdiction, my lord, even in a civil court also, civil case. That's where, my lord, the issue arose, my lord, and it was referred to the larger branch, my lord. 11, my lord. In dealing with the powers of the High Court under 220 of the Constitution, this court has expressed almost in similar.
Which part you are reading here?
It's
11
page-
is different.
My lord, no, my lord, 11, actually, there are some sub-paragraphs here. That's the problem, my lord. It will be, my lord. It starts with dealing with the powers. In dealing with the powers of the High Court under Article 220 of the Constitution, this court has expressed itself in almost similar terms. So and so versus so and so. Such reads are referred to in Article 227, obviously intended to enable the High Court to issue them in grave cases where their subordinate tribunals or bodies or officers act wholly without jurisdiction or excess or in excess of it, or in violation of principle of natural justice, or refuse to exercise the jurisdiction vested in them, or there is an error apparent on the face of the records.
All these five, Mr. Doctor,
My lord.
all these five is found to be, none of this
My lord.
is found to be present. That is why I have taken you
My lord.
to all the provisions
My lord. My lord. My lord.
of the Land Giving Act,
My lord.
as well as the operative part.
My lord.
It is not a case of lack of jurisdiction,
My lord,
not in excess of it.
my lord, lack of jurisdiction can also be, my lord, non-exercising of jurisdiction, my lord.
What non-exercising jurisdiction?
Lack of jurisdiction, my lord, can be non-exercising of
Are
jurisdiction.
you,
my lord.
were you hard or not, mister?
I was hard, my lord.
Huh?
I was hard, my lord, but then the
No,
issue.
don't interpret which is not there.
My lord, my submission.
Please.
My lord. My lord.
This is one thing is grave cases.
My lord.
Right. The grave cases are manifest error, right?
Yes, my lord.
Whereas subordinate tribunals or bodies or officers act wholly without jurisdiction. Can you say that in your case?
My lord.
Can you say that in your case?
No, my lord, my, to such
Please,
extent.
yes or no?
My lord, that
If
I'm,
it is is it your submission coming from your side?
my lord. No, my sub.
Wholly without, wholly,
My lord.
not without jurisdiction.
My lord.
Wholly without jurisdiction. Please,
No,
please,
wholly without
every
jurisdiction.
word has
My
significance.
lord, my lord.
Please,
My lord.
yes or no? Are you referring this petition
My lord.
that this tribunal
My lord.
did not have any jurisdiction at all?
No, my lord.
No.
No.
So,
That is not my case.
so let us examine.
Yes, sir. That is not my case. That is definitely not my
Then in excess of it, what did it?
case.
I took you to the provision.
Yes, my lord. To certain in excess of it, my lord, the compensation that has been awarded, my lord.
Oh, that is Mr. Doctor.
My lord.
That is not in excess of jurisdiction.
My lord, here
That
he has-
is not.
my lord,
Okay,
here
okay,
he has
okay. You,
failed to exercise jurisdiction, my
okay,
lord.
okay, your submission.
My lord, my lord.
Your submission.
My lord.
Okay.
My lord. My
In
lord.
violation of the principle of nature
Natural
justice. Did you
justice.
take part?
My lord.
Did you take part?
Yes, yes.
Did you
No,
take
no,
part?
That's not my case.
Whether you were asked to adduce evidence?
Yes, my lord. Yes. Those things are there.
Asked to adduce evidence?
Yes, yes.
Okay.
Those things are not, my lord, complaining.
I have not gone through the judgment.
Yes, yes, my lord. I took part, my lord. I did not reduce, my lord. I did not reduce evidence, my lord. That's a mistake, my lord. Committee. I did not reduce it.
That is now not open.
No, my lord, my lord.
Refuse to exercise a jurisdiction vested in them.
Yes, my lord.
Is it there? No.
Error,
There is an apparent
error
error
on the face of the record.
record.
Yes, my lord. That I would submit, my lord. There is an error apparent, my lord. That will come to that, my lord. And act, omission or excess has resulted in manifest injustice.
And such act. Such act.
Such act.
This is combined.
Yes.
This is combined. Error. This error
Yes.
should be such an act or omission
Resulting in
or
manifest
error,
injustice.
excess that has resulted in manifest injustice.
Manifest.
These are combined.
My lord,
Last one.
my lord.
Okay, let us read further.
My lord, however extensive the jurisdiction may be, it seems to us that it is not wide or large enough to enable the High Court to convert itself into a court of appeal and examine for itself the correctness of the decision impugned and decide what is proper view in view of the to be taken in the order to be made. The passage indicates the sufficient fullness, the general principle that can govern the exercise of jurisdiction in the matter of granting writ of certiorari under Article 226 of the Constitution. It is necessary to clarify that judicial acts is not meant to refer to judicial orders of civil courts, as the matter before the court arose out of an election tribunal and no direct decision of this court, except Surya Devi Rai, has been brought to our notice where the writ of certiorari may have been issued against an order of a judicial court. In fact, when the scope of jurisdiction arose in different decisions, it is clarified that judicial courts stood on a different footing than from quasi-judicial orders of authorities or tribunals. In Uzambai versus State of UP, matter was referred to the division a bench of 7 judges on the scope of writ of certiorari against the order of assessment of provisions of sales tax law passed in violation of the fundamental right. Moreover, majority of 6 judges took the view that except an order under an void law or ultra virus or without jurisdiction order, there could not be violation of fundamental right by a quasi-judicial order or statutory right, and no such order could be challenged under Article 232. Writ of certiorari, however, lie against patently erroneous orders under Article 226. It is observed that judicial orders of courts stood on different footing. Iyengar Justice observed. Before concluding, it is necessary to advert that one matter which are just touched onto in the course of the arguments as one which might have been reserved for consideration when it actually arose, and this related to the question whether the decision or order of the regular ordinary court of law, as distinguished from a tribunal or quasi-judicial authority, constituted or created a particular statute which can be complained of as violating fundamental right. The salutary principle that this court shall not pronounce on points which are not involved in the question and raised before it, and this is the reason why I am not dealing with the fullness and certainly not expressing in
Now, in this case, by the provisions by the statute, the special tribunal is deemed to be a civil court. By the legal fiction, it has been made a civil court. So it is not unlike the discussion here, quasi-judicial or something like it is deemed to be a civil court and it will follow CPC.
But then it has all the trappings of
Now,
tribunal. Because
that is why first, then the district and session judge and such others. Now, having gone through the judgment in Nandini Shah, that was rendered in the context of Public Premises Act. Now there, Supreme Court has said that discuss the concept of persona designata, right? And there it said that when it is a pre-existing judicial forum, there also appeal lies to the district judge. When the thing is not a persona designata, and if it is a pre-existing forum, which exercises judicial power, right? In that case, it will be 227, never 226.
But here the difficulty is, Ballot, the appellate forum has not come into.
Right. No.
That is creating all the problem, Ballot. Otherwise, Ballot, things have been different. Ballot, it's not a case where the law did not envisage a tribunal, Ballot. The law envisages a tribunal.
No.
A tribunal.
I'm not saying that your door is closed.
No, I understand, man.
Mr. Doctor, I'm not saying that.
Man.
I am examining whether it is 226 or 227.
Absolutely.
Because we are dealing on the civil side. Civil jurisdiction, civil liability, civil court, CPC, and district judge or additional district judge. These are the factors which will determine whether it should be Because it is a purely a judicial order. Right. Law also, if you go flip through all the judgments, when it is a judicial order, there is no question of violation of fundamental right.
That's true, madam. That's
Right.
That's true. That's true.
These are the factors which are tentatively subject to correction, are in my mind. Right. That is what I am on. Your door is not closed,
I understand that.
but wrong exercise ultimately,
Yes, ma'am. That-
ultimately will lead to complication for you only.
Yes, ma'am. That's
If
true.
it is not cured at the beginning.
True, madam. True.
And the people will start filing repetitions, and it will be difficult. We cannot close the floodgates. But if it is decided,
Well.
then everybody will file
True, madam.
the proper
Proper
petition.
Proper petition.
Right.
That's true, madam.
And that can be tested.
Obviously.
If
Obviously.
this order is passed, suppose, if I think that repetition is not maintainable,
Madam.
then intercourt appeal will be available.
Available.
But if it is treated as 227,
Madam.
then that intercourt appeal will not be available.
Yes,
I will
yes.
understood what I am saying.
Absolutely, absolutely, absolutely.
I'll decide the issue in a repetition,
Madam.
either this way or that way.
That way, madam.
Your repetition will be, there will be intercourt appeal.
Madam.
Let us patent appeal
Madam.
before the division bench.
Yes. Yes.
But suppose you prefer a 227
Madam,
petition,
then that's not it.
and that court decides that no, 227 is not maintainable. It will pass an order in 227.
Yes.
Then intercourt appeal will not be available. Right?
Absolutely, madam. Absolutely.
So it is a tricky issue.
Tricky issue, madam. That's true, madam.
Yes. Have you understood
Madam.
what I am pointing out?
Absolutely, madam. Absolutely.
Gosavi? We'll take it up on a hearing date.
Madam.
So that lesser pressure.
Madam.
Go through that Nandini Shah,
Nandisha, madam. Yeah, got it, madam.
LIC versus
It was Nandisha, madam. Yes.
Nandini Shah. That persona designator was discussed.
Yes, madam.
I think Asani judgment to Mutter.
I have it. I've got it.
There it is specifically, I think, how many judges?
Well, it's 3 judges, madam.
3 judges.
Yes, madam.
Here it has been categorically held
Yes.
that in such cases, it cannot be 226.
I'll also look into that.
Find out from that. Yes, Mr. Gusabi, can you render some assistance by this code? Because that, I was thinking of deciding that one, that has gone out of my. Just to can find out the case number to Kimanos. If some
Even
other
if,
code,
even if it is entertained, my lord, he has to establish the perversity.
but that is entering into the merits.
Yes. Waiting in my
In
consideration.
227, legality,
That part-
propriety, all these things can be gone into.
Right.
But here if I exercise 226, that fundamental right is not available.
Yes.
Against the judicial order, all these things will come again. It will create more difficulties for him. I'm thinking about the cause of
No, Lordship,
about the
right.
petition also.
Only thing, my lord, under the rule of law, nothing is left unsuited, my lord.
No,
That is
I'm not
always-
answering.
Yes, yes. That is as
Lordship,
exactly your lordship has explained.
Lordship basically decides the question of whether it will be 226 or 227. Then none of the question is.
No, because what I have heard, I don't know, subject, that I have also decided 226 because in 226, that
Yes,
being
ma'am.
case.
Yes, Lordship,
Right.
like they have seen.
Because after 7-8 years,
Right.
it has come for
Yes.
a hearing. No point relegating him to
Yes.
some other forum now. That is, that can be done
Yes, ma'am. I've seen the judge.
in the absence of the appellate tribunal. That we did. But what I have found that writ petitions are entertained as well as 227 petitions are entertained. Writ petitions are also entertained under 226 against land grabbing court, and petitions under 227 are also entertained. So some anomalies are being created
That has to be sorted out.
because we all are entertaining everywhere
True.
because of the HUD, Mr. M. Dr. Learned Counsel for the Petitioners, and Mr. B. Goswami, Learned Additional Advocate General, Assam for the assisted by MS N. Bordoloi.
He will also be there, madam,
Huh.
because
Assisted by N. Bordoloi, Learned Standing Counsel Revenue for the respondent number 1, and Mr. H. Sharma, Learned Additional Senior Government Advocate Assam for the respondent number 2 and 3. So stop. Release the case for further
10 to 15 minutes.
consideration. Can we have it on 17th, Saturday?
17 open, madam.
Open.
Then we can have it in 17.
7.
This was adjudicated during 2022. Entire 2023, they did not come forward.
Which one?
This
Petitioners,
case was
in the
ordered
present
on
case.
22.
The judgments in question, madam.
Huh? Within time?
In the
1 year
sense-
lapse only.
Writ petition, therefore.
That is
Otherwise,
all.
so appeal is not time.
Huh?
Even if it is.
Oh, no. And there now this thing have come also. That suppose, now your case is different. If appellate forum is available,
Yes, my lord.
and suppose 90 days limitation period to approach,
Yes.
Although, my lord, there is no.
but you did not approach the
That's a different issue.
appellate forum.
Yes, ma'am.
On 91 day,
Yes, my lord.
you file a writ petition,
That will not do.
throw it out.
Yes, ma'am.
But in any case,
Just like
he
in-
ought to have come, my lord, earlier.
Anyway, this,
My lord.
he is remediless.
Yes. No, that is why, my lord. I am
State-
support in that front. I am
State
supporting.
has not constituted the special
That is where
court.
the entire problem is.
I have personally become.
So 27,
29.
27.
No, 29, I have personally
Or
become.
27.
27. Diploma.
27, it will come as a motion.
My lord, my lord. Diploma.
Yes, Mr. Goswami, it's another thing.
My lord.
Next one is also. Yes,
It will need.
Mr. Sharma,
Lordship, I tried my level best, Lordship, but unable to. But that Article 12, Lordship.
But I had also seen a judgment where it was said that the state of Assam cannot be represented by the district commissioner. But here I have not made the state of Assam, but the district commissioner as an authority is a respondent.
no, state of Assam cannot be represented by district commissioner. If you see the other secretary, deputy secretary, joint secretary, additional secretary, or secretary,
Lord.
principal secretary,
Lord.
commissioner secretary,
Lord.
not deputy commissioner.
Lord.
Only recourse is that you file an impleadment petition.
But here I have not impleted the state of Assam, Your Lord.
That is what, make an impleadment petition. Application. Or if you want to decide on the preliminary issue, then we'll decide. This is not. State of Assam cannot be represented by, because you have directly made a deputy commissioner.
Yes, yes, Your Lord. I have not completed. the
Because
state
that decision was rendered by division bench when the executive engineer preferred a writ appeal.
That was not reported, I think, Lord. That I
But
tried.
but I am quite aware of it.
Reported, Lord.
No, I don't. That I
Yes,
don't
Lordship.
know.
That is, I am trying to, and I have also discussed with my colleague friends also, Lordship, but
Okay, we'll keep the maintenance issue open. We'll issue notice.
without a state lordship, how a writ lies. Lord.
We'll keep the issue
That is-
open. I asked for
Lordship.
assistance from
Lordship,
the
Lordship.
councils, which I have not got. So I have to do the research myself. So I'll keep the issue open. Maintainability. Heard Mr. S.
I
Day.
have filed for legal aid.
learned counsel for the petition. And Mr. H. Sharma, additional senior government advocate, Assam, for the respondent number
Lordship,
1 and 2.
may I just make a submission, my lord? In respect of the merits of the case, my lord, if your lordship kindly looks at the merits.
I'll not try first issue on the maintainability.
Then,
We will simply issue notice.
then lordship may
We
kindly,
will not go into the merit.
then lordship may kindly fix it on Wednesday, my lord. On
Wednesday is holiday.
Wednesday, my lord, then can it be on Tuesday if your lordship permits one case?
Tuesday we are full. Friday.
Friday, my lord. My lord, my lord.
Okay. On the prayer of the learned counsel for the parties, please the case on.
I will again try, Lordship.
I'll try.
I'm extremely sorry, Lordship.
I'll try. I asked
Yes, Lordship.
what to do.
Otherwise, under Article 226, my lord, it is provided, my lord.
When something is decided by revision means if it is correct, if I am correct, I cannot go beyond that.
I have also looked for such judgment that the district commissioner cannot be directly a party, but in other cases, my lord, before this honorable court also, there are.
Negative equality is not available. Somewhere, some petitions have been decided where only district commissioner is made a party. When it came to the notice and have some doubt,
Lordship,
then first doubt is to be cleared.
Yes, lord.
Item number 41.
Much obliged.
With item 37.
My lord,
Yes, Mr. Ghosh, what?
I have filed
Who is required to be implemented?
the allegation
No,
in the writ petition, my lord. Allegation in the writ petition is that I have that is petition applicants herein violated the terms and condition of the municipal bylaw and constructed the house. Against that, they made a complaint and the complaint was not disposed of by the authority. So they filed a writ petition earlier. In earlier writ petition, the direction was given to the executive officer.
1 minute.
Against that,
1 minute. Mr. Bonik, who was your neighbor?
we are the
Mr. Bonik, who was your neighbor?
So far as they are concerned,
No, who was your neighbor?
one to five are the neighbors. 1 to 5 are the neighbors.
Huh?
This presented.
No, in your petition.
Yes, they are neighbors.
As during the pendency of the repetition, Karimganj Municipal Board Authority has issued a demolition order in respect to the said building on 30/8/2023. The repetition was disposed of as nothing was found to have survived in the repetition. But the respondent is we have in a meeting held on sense of took a resolution to declare the demolition order as null and void on the premises the said demolition order was issued by the executive officer of Karimganj Municipal Board exceeding his jurisdiction. Okay, you have challenged the decision of the chairman or Karimganj Municipal Board.
Yes.
We say that on the basis of an order, writ petition was rendered infructuous and contempt petition
No,
was
I have
closed.
already recorded that fact.
Yes.
My lord, with respect to earlier decision, review is pending, my lord. In the review, they have appeared. He has not made mention in the writ petition also.
My lord,
Okay, do you have any objection here?
so far as 2, 3, 4, 5 are concerned, we have no objection. 2, 3, 4, 5. 2, 3, 4, 5. So far as 1 is concerned, Govinda Dev, at page 32 of the writ petition, my lord, in the earlier writ petition, on his own statement, his name was struck off. And thereafter, a review is pending. So ipso facto, he may not come in now. That may be out after the review petition is done. Page 32 is the writ petition, the first round. Lordship finds at page 34, the operative power which I'm referring to. Page 33, last part. Page 33, last part, paragraph 4, starts there.
Page 32, he is respondent number 6.
Page 32, Your Lordship.
Respondent number 6.
The last part now, my lord.
Yes, respondent number.
Paragraph 4,
Paragraph 4.
page 33. In view of such categorical statement, this court is inclined to record that Shri Govinda Dev, respondent number 6, is not a party who may be aggrieved by any order that is passed in this proceeding, as he does not claim ownership right over the property of his deceased wife. Therefore, the name of respondent number 6 is struck off, registering do the needful. Therefore, the review is pending. He may not come in.
I have filed review against this statement.
That is not,
And
that is not allowed till date.
Not allowed.
not allowed, but notice has been issued. And
That doesn't mean that it is allowed.
with respect to Govinda Dev, my lord, it is law regarding the succession.
Have you annexed the affidavit in opposition filed by respondent number 6?
In the affidavit,
Mr. Monik, do you have the copy of
I do
that?
not have
there
it.
is not a single mention, my lord.
You bring that, we'll decide this.
But so far as the review is pending, let respondent numbers 1 implement be subject to outcome of the review petition. I would not have orders then. But 2 to 5, I'm not objecting. I'm not objecting 2 to 5, fairly.
Because of your categorical stance.
No, that was actually in the affidavit in opposition, there is not a single statement.
No, your review petition.
Yes, in the
Number
is 99 of 2023.
23. It is still pending. It is not decided.
Not
Not
decided.
decided.
Not decided.
And it.
Then the coordinate bench is available.
Yes.
Yes,
And that review order on review is to be passed by the coordinate bench.
two count review has
As
been
on
filed.
date.
Yes, yes.
That decision stands
My lord,
wrong submission by the council. That is a different
yes,
issue.
that is,
But as on date, it is standing.
my lord, one thing, my lord.
2 to 5, he is not objecting.
not objecting.
And one
One is
regarding
important.
implement, he has rightly pointed out.
But my lord, what happened? Wrong submission or incorrect submission, not wrong submission, incorrect.
After the review petition is allowed, you come, push another implement application, will allow.
My lord,
So what may not be
my
allowed
lord,
to see?
law regarding succession after death of the wife, whether husband is entitled or not.
Mr.
And this on the basis of incorrect submission, the court has taken view against the law, my lord.
Court has
So that
taken
is
up-
why I have filed a review.
File and get it allowed.
And apart from that,
Get it allowed, Mr. Ghosh. As on date, that order stands and there is no stay order.
my lord, it was
Notice has been issued.
it was heard also in his presence. He
decided.
wants that
Decided or not decided?
not decided.
Not decided.
Not decided. And he prays for time to file objection in the review petition. He has not filed.
That is maybe the professional craftsmanship of Mr. Monik that we will not
Now, gentleman has.
But
make any
But
observation.
here in this case against law, this,
Heard Mr. S.K. Ghosh.
and what harm? He is the father of respondent, the applicant number 2
No,
to
something,
5.
when something is pointed out to the court and court feels that it is not the.
My lord, then it may be taken along with this review application, my lord, because original order.
That
is
court,
standard
that,
challenge.
Mr. Ghosh, I cannot, because that court is not having the roster. Presently. This has to be by way of administrative order of the Honorable Chief Justice. Heard, Mr. S.K. Ghosh. Learned counsel for the applicant. Applicants. And Mr. S. Monik. Learned counsel for the opposite party number 1. Opposite party number 1. That's writ petition. Full stop. The instant application, interlocutory application has been preferred by the applicants, seeking their implement as party respondents in the connected writ petition, WPC number 7620/2023, preferred by the opposite party number 1 dash as the writ petition. Full stop. Mr. Bonik, learned counsel for the opposite party, number 1 dash writ petition, has contended that the applicant number 1 herein in an earlier proceeding, writ proceedings,
Page 32.
comma, of WPC number 1749/2022. During the consideration of a previous writ proceeding, comma, WPC number so and so, made a categorical statement before the court that he was not the owner of the property comma, in respect of which the said writ petition was preferred. Full stop. In the said writ petition, WPC number 1749/2022, comma, the applicant number 1 was impleaded as party respondent number 6. Full stop. So, by filing a affidavit in opposition, in the said writ petition, comma, the applicant number 1 as the party respondent number 6 filed a writ petition on 31/8/2022. Full stop. When the said writ petition, WPC number so and so, was considered on, came up for final consideration on 20/01/2023. It was submitted on behalf of the party respondent number 6 therein, that is the applicant number 1 herein, that the owner of the property within bracket house was the deceased wife, was his deceased wife, within bracket Subharadi Deb. And after her death, comma, he did not become the owner of the property within bracket house. Full stop. In view of such categorical statements made on behalf of the applicant number 1 as the party respondent number 6 there in writ petition number so and so. No. The court recorded that the party respondent number 6 therein, that is the applicant number 1 herein, was not a party who was aggrieved, who was to be aggrieved by any order to be passed in the said writ petition, as he did not claim ownership right over the property within bracket house of the deceased wife. Full stop. With such observation, comma, name of the party respondent number 6 in the writ petition WBC number so and so. That is the applicant number 1 herein was struck off. Mr. Ghosh, learned counsel for the applicants, has submitted that agreed by the said order dated 20/01/2023 passed in WBC number so and so. The applicant number 1 as the petitioner has preferred a review application, review petition number 99/2023. And the said review petition is pending. Stop. Para. Mr. Bonik, learned counsel for the opposite party number 1, that's the petitioner, has, however, raised no objection as regards the prayer for implement of the applicant number 2 to 4.
5.
2 to 5. Full stop. Having gone through the statements and amendments made in the instant interlocutory application, and considering that Mr. Bonik, learned counsel for the applicant, opposite party number 1, the state petitioner has no objection, the instant interlocutory application seeking implement insofar as the applicant number 2 to 5 as party respondent in the connected petition is concerned, is allowed. Full stop. As the review petition number 99/2023 is pending for consideration, and in view of the findings, observation recorded in the order dated 20/01/2023, passed in the writ petition, WPC number 1749/2022, the prayer made on behalf of the applicant number 1 herein for his implement as a party respondent in the connected writ petition WPC number 7620/2023 is declined at this stage. At this stage, I'm giving it open.
But they may file the application before the registry. 2 to 5.
Mr. Learned counsel for the applicant will file now. You file amended cosme, right?
But this is the applicants could file, the amended cosme.
Okay.
Actually,
Learned counsel for the parties, I don't know.
actually.
That is
this-
vague, that is vague.
Yes, that is.
Shall file amended cost title.
That may take time. He has to come down and sign. Otherwise,
In terms of the notification, it is so and so before the registry within 7 days from today.
My lord, in original writ petition also listed.
original
Along with-
petition, my lord, steps we have taken. It was dispatched on the 6th. We have taken sometime in 12th of January
The
Service
title
available.
is the repetition so and so
on completion of service.
after amendment of the cost title.
Good. Obliged.
Much.
I restore. Yes, council assisting.
Lordship, I am there.
Except in High Court rule. In 2006, rule was amended. Lordship, page 56.
Yes, 56.
Lordship, E. Close E. Lordship. The writ petition in which the constitution validity of any act, rule or any provisions thereof have been challenged. Lordship.
Now, which one is challenged?
Lordship,
Which one is challenged here?
here, Lordship, one notification has been challenged that was passed
Okay.
under section 168 of the CGST.
Lordship
Which
notification,
paragraph? Let me have a look at least.
Lordship,
Page 45. Better Lordship may come to the prayer of the petitioner.
Hey, GST account.
Hmm. 168A is at page number 8 of the petition.
By this notification, central government has exercised a power
Yes,
which has been conferred by section 168A.
for extension of time.
So it is 168A is not challenged.
Not well.
The power exercised under 168A is challenged.
Lordship, come to page 40.
So if we go by this
Yes, Lordship,
E
validity of
of any act,
rules
rules
or any provisions thereof.
thereof have been challenged. Now here 168 is not challenged. Now come to section 20 perhaps is same in similarly worded provision. Section 28 to 20 of the IGST
Yes, Lordship.
and perhaps section 21 of the UGST
Yes, same.
are similarly worded provision,
Yes.
perhaps. So power has been exercised under 168A,
Implement the notification.
challenging the notification. I don't think this will come because had it been 168A,
That's by making this submission because similar repetition was preferred, that was come for the single judge. That has been referred to division bench.
it has been listed.
Listed, but the petition.
Show me the order.
Lordship, note has been passed because petition took time for a week. It was listed on last Monday.
So whether court has passed an order?
No, nothing, Lordship.
Then
Petitioner took time to make their argument before the division case, Lordship. They have not made any argument. Only single judge has referred the matter because it is something has been challenged, so that will be listed before. That was the view of the single judge.
any order, no
No
order.
order has been passed.
So
And Lordship, for
I have
that, Lordship, may please to see where A, page 41, prayer. Because multiple prayers have been made in this writ petition. A is with regard to they have challenged the virus of the provision,
Lord, no lordships.
holding that the notification.
Tera, tera,
So, is
page 41, A or B?
A, Lord.
This is notification. He's
Not-
saying
No, Lordship, I'm just pointing out. Lordship will decide. Lordship then pray D, Lordship. Provision of section 64 has not been challenged. But Lordship, may please to see the pray D. Pray D, Lord. To issue writ of mandibus and or any other appropriate writ holding that section 16(4) of the CGST AGST Act 2017 provides for availment of ITC by a petitioner within stipulated time period and non-filing of the return of the supplier within the stipulated time period cannot be denied the benefit of ITC accrued to the petitioner. Lordship, section
and now, sir, here you are holding that section
and Lordship, this section has been put under challenge before decision of
provides for availment of ITC by the petitioner within a stipulated time period and non-filing of return by the supplier. Section 16(4) is not in challenge.
No, Lordship, that is challenged before decision of court in another writ petition, the notice has been issued. And in the meantime, Lordship, what happened, 4 high courts has upheld the validity of section 16(4). Now, in one of the writ petition in Patna case, the petition has filed SLP, but no stay has been granted. That is on 3rd of January 2024. Lord. And with regard to Andhra Pradesh High Court, Telangana High Court, and on another Jharkhand High Court, they have upheld the validity of section 16(4). Lord. In our High Court, petition is pending.
This pair D, I think, for basically interpretation of section 16(4),
No, Lordship,
not challenging the legality.
no, here it is not there, but in another writ petition, they have been challenged. And it is fixed for final hearing. The name of the petitioner is MP Agarwal, but his station of the
16(4) is challenged.
Yes, 16(2) is also challenged, that is also pending before decision of court.
But so far, this 16(4), I don't think it is in challenge.
Here it is not challenged. In this writ
Or
petition,
168A is also not in challenge.
no, Lordship, that is correct. Only that notification is there. That was my precise submission for the Lord. Probably this notification for the first time it has been put under check, particularly this notification.
Notification. Okay, Mr. Kanodia, I
Worships.
don't think perhaps we can go ahead with the writ petition.
Grateful to your lordships, grateful to your lordships.
Okay.
Let it be on Monday. You avail virtual
But I have virtual.
because this court will be rising today early.
No worry, I go down to your lordships.
Heard Mr. G. Kanodia,
Ek.
A. Kanodia, Learned Counsel for the petitioner through virtual mode, assisted by Mr.
Zaid Islam.
Zaid Islam, Learned Counsel for the through virtual mode, assisted by Mr. Zaid Kanodia, Zaid Islam, Learned Counsel for the petitioner, and Mr. S.C. Kyle, Learned Standing Counsel, GST, full stop. So that notification where that one is challenged in the coordinate bands, coordinate bench has not passed any order referring it to the revision bench.
No, Lordship, they filed a writ petition before the division bench now. Lordship. But on last occasion when it matter was raised, their counsel was outside counsel was there, so he was not.
When it is posted?
Lordship, after a week.
Huh?
No date has been given, Lordship. No date has been given.
No date is given. If that division bench entertains the similar challenge,
No, this notification is not put under challenge. Another notification is challenging that.
okay, okay, that leaves the case. Leaves the case Monday.
Grateful to your lordships. Grateful.
Obliged. Much,
Much obliged.
What are no steps, item number 14.
Yes, what you were submitting?
May I please your lordship?
Ah.
But with due apology, my lord. I pray some time to take fresh my lord step, my lord. In earlier occasion, my lord, very next day, my lord, the vacation was started, my lord, after this order, my lord. 22/12 order. my
This is
lord.
the owner, the president from Monica sir.
Due to some misrepresent, my lord,
There's some wastelands.
Miscommunication on-
There, Patalens.
my lord.
Hmm.
But due to some miscommunication on our part, we could not, my lord, take this step, my lord. And no interim is order, my lord.
Heard Mr. M. Islam, learned counsel for the petitioners. B. Goswami, learned additional advocate general, Assam, assisted by Mr. M.S. N. Bordoloi, learned standing counsel, revenue department for the respondent number 1. Anybody PWD? And Miss M.
B. Gogoi's name. may be
B.
recorded.
Gogoi, standing counsel PWD for the respondent number 2 and junior government advocate M. Bormon, S. Sharma. The junior government advocate Assam for the respondent 3, 4 and 5. Full stop. Mr. Islam has submitted that due to regions beyond control, his control, comma, he could not take necessary steps for service of notice upon the respondent number 6 and 7 in deference to the order dated 22/2/2023. Full
I
stop.
think my lord,
Yes.
he has not furnished any copies to
My
any
lord.
of the.
Anyone,
Extra copy also, my lord.
any.
No copy also. Mr. Islam has further submitted that he could not, for the same reason, comma, he could not serve extra copies of the writ petitions to the learned counsel for the respondents in reference to the order dated so and so. Full stop. He has prayed for 2 working days time to comply with the directions made in the order dated 22/12/2023. Full stop. The prayer is allowed. The petitioner shall take steps as per the order dated 22/12/2023 within 2 working days from today. This is the case after 4 weeks.
Highly obliged, my lord. Item 16 and 17 for admission.
May please, your lordship.
Yes.
Your
Yes,
lordship.
Mr. Affidavits are filed or not?
My lord,
You have filed your affidavit.
NSL itself filed affidavit, my lord. We have received the instruction, my lord, at the map also, my lord, whether he is on the reserve forest or not, my lord. He is, my lord, reserve forest, my lord. And the
Do
after,
you have the notification of the reserve forest?
my lord,
Tell
that
me.
that is another case, my lord. This is another case.
No.
My,
Your NHIDCL stand is this acquired land falls under reserve forest.
my lord, that is our stand also,
Your stand also.
also, my lord,
Now, reserve forest
my lord.
to be declared as a reserve forest requires a notification,
My lord,
right?
my lord.
Under Assam Forest Regulation
Regulation, my lord,
1891.
my lord.
Or if not applicable, suppose in KAC,
All right.
then Indian Forest Act 1928.
Yes, my lord.
Right?
Hmm.
So do you have the copy of the notification?
At this moment, no, my lord.
And Mr. Botagod, you place. He will also place.
My lord.
That will cleanse the issue.
My lord.
If the petitioner's patta,
My lord, Patta also, my lord, I have the.
wait,
My
for
lord,
your
my
consideration,
lord.
if the petitioner's pattas are subsequent to declaration of reserve forest, then it will be one issue. If it is prior to declaration of reserve forest, then it will be another issue.
Our contention is that Patta is issued not at the approval of the autonomous council, and it is issued by some persons, and we are not recognizing that. My lord.
Okay, but that
We'll
we-
file affidavit.
that also issue request that notification.
My
from-
lord, my lord.
Heard Mr.
In the meantime, my lord, if my lord may kindly allow me. Now, as the matter has been taken up before the Zolmo court, behind the back of the Zolmo court, the work has already commenced, lordship. The trees are being felled. Now, lordship, the rights of the petitioners.
Are you
Yes, lordship.
maintaining inventories or not?
Lordship, due to their hindrance, Lordship.
Mr.
My lord, there is nothing, my lord. I have the video also. Only the, my lord, forest land is there.
Forest
No house, nothing is
Nothing.
there. Nothing structure is there. If they are entitled also for the compensation, your lordship, if the honorable court decides that they are entitled, they can get the land compensation. Not on the, my lord, there is nothing, jirat, nothing like that way.
There
you
there
have
are
any
many
house?
trees, lordship.
Do you have any house structure?
No, lordship, but there are
Do you
many
have any
trees, lordship.
structure there? Or?
No built structure, it's not there, lordship, but the trees are being felled, it's being uprooted, lordship. So
Trees-
as my lord has rightly questioned whether inventory has been maintained. If the inventory for the same is maintained, lordship, then
Because I
Yes,
think
lordship.
inventories are maintained because here there is a clearance under section 4 of the Forest
Act.
Conservation Act.
lordship.
And Kampa has come into
Yes, ma'am.
picture.
And about the 6 crores. or
Kampa has come into picture, Mr. Seki.
Yes, lordship,
Kampa has come into picture.
my lord.
And the
If
Campa
there
account
is
amount has been-
deforestation, there has to be afforestation.
My lord. And the amount was determined and that amount has been deposited. my lord.
So when central government is in picture
Yes.
with Kampa and all,
My lord.
there will be proper inventories.
My lord. Notification has already been issued on that campus account amount has been deposited.
Only thing is required to be examined
My lord.
whether your case is under section 5 of Assam Forest Regulation
My
or section 4 of the Indian Forest Act. If that is very significant.
It is, my lord,
For
district,
that, Mr. Bhattacharya has to.
my lord, it is a district council reserve forest, my lord. Under the act, we have our
You have
own
the
act, my
power.
lord, my lord.
You have the power.
For my lord.
6th schedule.
A 6th schedule,
Let us see.
my lord.
I'll specifically observe that.
My lord. District council at that Longtit District Council Reserve Forest.
Okay.
Paragraph 3, my lord, we have our own
No,
act.
no, constitution.
6th schedule.
Because some issues otherwise, if not recorded,
My lord.
later on in the
My
next
lord,
day
my
again
lord,
will forget.
my lord.
Noted.
6th schedule, para,
3, my lord.
so that you can controvert.
My lord.
My lord.
Lordship.
We file the
That
affidavit, my lord.
Make the task easier. 3A,
3, my lord, 3. Paragraph 3.
paragraph 3, right?
Paragraph.
Okay.
My lord. The management B, my lord, subparagraph 1B, the management of any forest not being a reserve forest. Management of a forest,
A makes it clear
my lord,
that you have no authority to declare reserve forest.
my lord,
Is it not?
my lord. But management of any forest not being a reserve forest, B,
Now,
And-
management of any reserve forest.
my, no,
It is not declaration of
any
forest.
forest not being a reserve forest.
Ah,
So, my lord,
okay.
we have enacted our own act under this, my lord, paragraph 3(1)B.
How can you declare reserve forest?
My lord, by in exercising of that power, my lord, we are, my lord, whether it is valid or not, lordship may decide,
Oh.
but we have enacted.
You have
own act,
created
my lord.
another problem.
My lord, and this is the, my lord, land, my lord, of the district council reserve forest, that.
You cannot declare reserve forest.
My lord, lordship may decide this issue, my lord. Let us find
I
the
think you have
affidavit.
created one more
My
issue.
lord. My lord,
I think they can only create a reserve forest.
Lordship, these are the issues.
You can manage a forest. What is forest then? One is for a reserve forest. Then what is forest?
My lord, the management of any forest,
You can only manage a forest
my lord,
and enact laws.
my lord,
You cannot declare a forest,
my lord.
not to speak of reserve forest.
So, my lord, I will also look in it. The book is not with me also, my lord. We have our
But
own
Mr.
accord,
J. where you have created more problems now.
my lord.
Learned counsel for the petitioners.
To me, these are the criminal plummeted reserve forest.
Mr. I. Botagul,
District council reserve forest.
Oh, district council is there.
learned standing council, Forest and Environment Department, Assam, for the response number 1 and 4. Huh? I'm taking up this 5812.
Oh, no, it is earlier case. Lordship.
5812 Harry
They have
amendment.
amended repetition have been filed.
Huh?
Yes.
I think first title was amended as subsequently.
Movie to Tulki Dulan Bhai, I did one thing.
Wood back was title.
Seven.
Lordship, the first writ petition 5812 is not amended. It's a 768. The second writ petition of 2023 is amended, Lord.
অকল এইটো দিয়ক তাৰপিছত অকল এইটো লিখিব
I have just.
অকল এইটো লিখিব তাৰপিছত লাষ্টত লিখিব লিষ্ট দিছ কেছ বুলি লিখিব লাগিব হা No, these petitions are same or what?
Same.
Lordship, yes. On a same
Petitioners
subject,
are same.
Same.
Yes,
In both the writ petition,
my lord.
right?
Yes, Lordship.
So,
But prayers.
okay, WBC 768 or লিখিব হা
It is amended.
JSAKI petitioners in both the writ petitions. We'll simply record the name and designation. Will not show the party number. MS Arbora, Learned Standing Council, NHIDCL.
So earlier, we are not made party, so they have filed amended.
MS Mr. J. Sutia, Learned Standing Council, KASC.
I am for NH.
Mr. C. Borua, Learned Standing Council, NHAI. MS N. Bodoloi, Learned Standing Council, Revenue. Any other party? No. Full stop. You have filed your affidavit where?
Lordship. We have
Which
Five
meeting?
eight one two. 5812.
5812, because they have filed this
1
miss
minute.
case
1
for
minute.
stay of the construction of the
1
road,
minute.
5812. Yes, it is 500.
13.
5812.
At least stay.
Stay.
It is submitted by Mr. Sutia, Learned Standing Council, KAC, and MS Bora, Learned Standing Council, NHICL,
DCL.
NHIDCL, that the parcels of land in respect of which the petitioners are claiming compensation,
My lord.
comma, fall under Longneet
Longneet.
District Council Reserve Forest. Right?
Madam.
Full stop. Mr. Sutia has further contended that Longneet DC District Council Reserve Forest has been declared by the respondent Karbi Anglong Autonomous Council
Yeah.
in exercise of powers under paragraph 3, small b of the 6th schedule to the Constitution of India. And as such, the petitioners cannot claim title stroke ownership in respect of those parcels of land which fall within a reserve forest declared by the K respondent council. But you have to substantiate your submission.
My lord, it is, my lord, on the basis of the, my lord, affidavit submitted by the NSADSL, I'm submitting that, and, my lord, that word is there, my lord, DCRF. So this DCRF, that means, my lord.
I think that is right.
That is.
Otherwise, I'll be in confusion.
Long need.
I have expanded it is.
My lord.
District council.
DCR, my lord, it is DCRF. So I presume that it is a district council. Presumes only the presume, my lord. That as
Okay,
without.
Might. Mr. Borthak, oh, sorry, Mr. Borthakur, standing council, forest and environment. Mr. Borthakur, the standing council, forest and environment shall obtain instruction whether Longneat District Council Reserve Forest is declared so by the state government under Assam Forest Regulation 1891. And if yes, he shall produce the concern notification by way of an affidavit. First up. This, Mr.
Lordship, by the Tampa.
We have paragraph 64. Second, we have already deposited an amount of rupees 7 crore 45 lakhs.
20.
Rupees.
MS Bora has further submitted that
Deposited.
since the state government on the request of the state government, the state central government, in exercise of powers conferred under Section 2 of the Forest Conservation Act 1970, has no, Forest Conservation. 1980. No, Indian Forest, not Indian Forest.
Forest Conservation Act
Conservation.
1980.
Forest Conservation Act.
Page
Section 2,
76.
perhaps, Section 2.
Page 76. Section, my lord, Section 2. Section 2 of the Forest Conservation Act 1980. Page 76. That is the approval of environment clearance. I am,
Has permitted de-reservation of the forest area for use and for use of forest land for non-forest purpose. More things are going to be
My apologies, Your
under
Lordship.
confusion.
I beg your Lordship's indulgence to the IA 295 of 2024 in connection with
What are you?
IA for stay of the construction work, Lordship.
Show me some structure.
Nothing.
Show me some structure.
They have annexed.
Otherwise, for land, if you succeed, definitely you are going to be benefited. But any structure, because deforestation, I have that is why I have recorded use of forest land for non-forest purposes. And statute requires how many trees are to be cut, how many trees are to be preserved. Deforestation is to be accompanied by afforestation under Forest Conservation Act. Keeping your interest in mind, I have recorded that.
My lord.
But show me some structure.
Lordship, as I have already submitted.
No structure.
There are no standing structures.
So
Lordship.
trees are to be accounted for
My lord.
under the central government direction.
Then, my lord, the
List
IA can be,
cases on.
can be disposed of, Lordship.
Which one?
The IA which is pending,
For
it can be
stay.
disposed of.
For stay.
The IE is for stay.
We're keeping it pending.
My lord, Lordship, Lordship,
We're keeping it pending.
my lord.
If you want decision,
No, Lordship,
let us keep it
We'll
for
keep it, Lord.
consideration.
my lord.
Who are to file? Mr.
Kala.
Sutia has said, prayed for.
Oh, Lordship, or my lord, if the IA can be disposed of, then with a direction by this honorable court that proper
Then
inventory should be
it
maintained.
will require consideration. I'll be rising at 1 o'clock. It is
My lord,
already
Lordship.
beyond 1 o'clock.
My lord.
If you need consideration of the IA, we can post it.
Or maybe on the next date, Lordship.
Straight for listing of the cases on
February 27.
4-3?
4-3, my lord.
40. Yes.
4-3?
Yes.
Lordship, the matters
To
are also-
enable him to file counterfeit on behalf of the respondent KAAC authorities.
My lord.
Lordship, endeavor may be made to dispose of the matter early, Lordship, because. public-
No, there are many things.
Lordship,
Everything, if everything comes on record,
Lordship,
we'll decide.
my lord,
That is why I have recorded
Lordship,
these facts.
Lordship.
First thing, we have to see whether Karbi Anglong Autonomous Council can declare
Yes,
an area as forest.
my lord,
If not, then that is not a forest in the eye of law.
my lord.
My lord.
Then your patta land will prevail. Right?
That
Yes,
other
lord.
point is
I
there.
am keeping all these things in mind. I have passed the order.
My lord. Blush, your lordship.
Of like
This is the cases on friends.
items 18.
There is a series 18 to 21. Who are the council? Yes, Mr. Talukdar.
Lordship, speeding to complete in this
Huh?
matter, your lordship may take it for hearing. Any convenient date as per your lordship's convenience.
Yes, what is the issue?
Lordship, we have challenged the election of. the-
Cooperative society, election. Mr. Bonig is always.
But it's not long back.
Cooperative society election, Mr. Bonig is omnipresent. MS
S. Sharma.
S.
S. Sharma.
Sharma. You are the petitioners everywhere
Yes, your lordship. In,
Okay.
item number 18.
for the petitioners. Mr. S.K. Talukdar, and Standing Council Corporation Department, and Mr. S. Bonig, Learning Council for the private respondent are present and have prayed for listing of the cases. After we post list the cases on data video.
After 4th of March, maybe.
4th of
Or
March.
after 4th week. After 4th.
Not the 11.
Lordship. Like.
We'll see.
People of your lordship.
All the issues.
Wait, please, Your Lordship, in this matter, compensation has already been paid to the petitioner.
Lordship, interim compensation has been given, that is an amount of rupees 75 rupees.
Final, something is processed, you come
Lordship,
whenever you are agree, we'll keep it open.
yes, Lordship, as per provision, your Lordship, till the
We
petitioner.
cannot, because they are proceeding with the matter. Means
Lordship may come to third page of this instruction. In the middle, there is an order dated 27/12/2023.
Okay, check has been issued,
Lordship.
right? Heard Mr. S.I. Akan, Learning Council for the petition, and Mr.
R. Chauhan,
R.
correspondent.
Chauhan, Learning Council, appearing for,
Respondent number 2.
Learning Council appearing for MS Archery.
Yes.
Standing Council ASLSA. Who so the petitioner has preferred the instant petition seeking a direction to the respondent authority to release compensation under the Assam Victim Compensation Scheme cover 2012 as amended. From the instructions placed by Mr. Chauhan, it is noticed that on the basis of the petitioner's application, a case, victim compensation case number 15/2022, has been registered by the district legal service authority, Golaghat. From the order sheet. Order sheets. Of victim commission case number 15/2022, placed before the court by Mr. Chauhan, it is noticed that an amount of rupees 75,000 has been disbursed to the applicants, the petitioners, via a check bearing number 168,539 dated 27/12/2023. Full stop. From the order, you have to prefer appeal.
Lordship, they are not mentioned whether it is final or interim.
No, full payment is done. The case is disposed of. You have to prefer an appeal.
Yes, Lordship, as per
Before-
the provision, they should pay 5 lakh, but they just only.
Appeal.
Lordship.
Where is the provision? Appeal provision.
Is at page number
From
35 of the writ petition.
Order dated 27/12/2023 passed by the Secretary, District Legal Services Authority, Golaghat. It is further noticed that with the disbursement of, by disbursing, the state authority has disbursed the amount of rupees 75,000 towards full compensation. Full stop. With the disbursement of rupees 75,000, the District Legal Service Authority, Golaghat, has disposed of the case, victim compensation case number 15/2022. Full stop. As the remedy of appeal under dash. Economic 9.
Follows 8.
Economic 9 notification.
Follows 8 for delay there is not.
The notification is at page number 35 of it.
That is delay.
Appeal is within 90 days. Section 8.
27 January, February, available.
Available.
As the appeal, remedy of appeal under clause 8 of the Assam Victim Compensation Scheme, 2012, notified by notification dated 18/10/2012 is available, the petitioner shall prefer, petitioner is at liberty to prefer an appeal if aggrieved by the amount of disbursement of the amount of rupees 75,000 by the District Legal Service Authority, Golaghat, as full compensation.
Great, much obliged.
Yes, any interim order somewhere? Somewhere, any interim order?
Yes, plus item.
Which one?
26.
26.
26.
Who is enjoying?
Lordship, short day.
Okay. Due to
Urgent-
early rising
very
of the
much
court
urgent to note
today
that, Lordship.
at 1 p.m., the cases could not be taken up. Post of the cases, elected the interim order passed shall continue till then.
Lordship.
Mr.
After a week, Lordship.
Huh?
I am praying for fixing the after. Lordship.
My lord, item 23.
If I go on spending time fixing the case dates, it will be difficult. Ask the